Alan, I just sent you the link.
Okay. Get it just a second. Yep, there it comes. Go ahead and get that posted. And that is now published, Miss Olivia, so.
All right, thank you. I'll move everyone back over.
Right.
emboli, so we're looking good so far, but that's what I've been dealing with, so that's why I've been sort of out of the loop.
There they
And
come.
Glenn, you got moved before you were able to finish, but we're now in the public meeting room.
Alrighty.
You have a quorum, so if you'll give us a second, the staff will get the live stream up and make sure people know how to get to join the meeting.
Everybody's good to go.
Live stream is up, Dr. Collada, so we're good to go.
All right, you can call the meeting to order, Mr. Chairman.
He's not there yet.
Oh, goodness, he didn't make it over. Jacinta, you want
There
to
he
see if we can
comes.
help him? Oh, here he comes.
I'm bringing
Got
him
it.
back.
Thank you.
You're welcome.
Yep.
There's our chairman coming back.
Warren's on mute.
Warren, can you hear us? There he is.
Okay, can you hear me now?
Hey,
Yes, sir, we can.
All right, I don't know.
Yeah,
what
you can call the meeting to order. Everything is ready for you to go.
All right, well, let's begin. Let's begin our June 23rd, 2023 meeting. It's 1:35. Let's have everybody that's present introduce themselves. For the record, I'm Warren Lowe.
Chris Rochelle.
Glenn Alley.
Darla Burnett.
Rob Dames.
I'm Vince Collada, Executive Director of the board, and I hope they'll give me a ability to share it. I'll put the agenda up.
Patricia Wilton, Executive Counsel to the Board.
I see Matthew's name on the screen. Is he here?
Yes, sir. Matthew Cook. I'm the licensing analyst supervisor with the board.
Okay. Anybody else that's present whose name is not up? I don't guess so.
You have our two executive staff members, Jacinta Dutu
Oh,
and
sure,
Olivia
sure.
Pilon.
Olivia. Okay, good, good. Okay. I presume we've determined that the agenda meets the criteria. I would like to add one item to the agenda. It requires a motion and a unanimous vote. It won't take long. I just want to clarify a couple of things on telehealth. So I'd like to add telehealth to the agenda if someone will make a motion.
Motion, we add telehealth to the agenda.
Second.
Good. All in favor?
Aye.
Okay, thank you. By
Be
the
sure
way,
there's nobody opposed, Warren, just to be sure to, for
okay,
the record.
sure, thanks. Anyone opposed? Okay, good, passes. Do we have someone taking minutes?
Do we need to take minutes? I can take minutes. I was not present at the last meeting, so I don't have minutes from the last meeting. But I can take minutes unless Jacinta, you're going to do that or someone there, but I can.
Okay,
It's all
Let's-
you.
Do what?
I said it's all you, Dr. Alley. You
It's
can take
all
it.
me. Okay.
Yeah.
gotcha.
Okay.
And
All
I
right.
have the minutes of the last meeting up if you can see it. I don't know if you can.
No, there's something up
No,
here.
the screen you're sharing is not, it's got
All right.
the homepage and then the,
All right, let me fix this. Hold on a minute. Can you see that?
Nope.
There
There
we
we,
go. There we go.
yep.
Where did it go? Okay, hold on a minute. Bring it back. I'm not sure why I'm having so much trouble today, but I'll figure it out. Okay. Okay, can you see it now?
Yes,
Yes.
All right, is it readable to everybody?
yes.
It is.
Okay, good. We got it going.
no,
That's not the right.
that's
minute.
not the right, that's
night-
not the Ed Psych minutes. That's the board member minutes.
Oh, wrong one. I apologize.
And we can see it though.
All right. Well, I'm getting to where we need to be. That's the good news. I apologize. All right, so let's see.
Dr. Claudia, would you like me to put it up? I have it.
I got it right now.
Okay.
All right, I had it in a second. Let me see. Okay. Yes. Okay. And share. And med psych. Here we go. Thank you. This should be it. Can you see it?
Yes. There's,
Yes.
Along with a whole bunch of other stuff.
All right. Well, let me get rid of that. Then let me fix that problem. One step at a time, as they say. All right. So can you see it all?
Yeah,
Okay.
1/8.
1/8.
Yeah, where it says, it goes from meeting agenda to introductions. That's all I can see.
All
Scrolling
right.
up.
Can y'all see the public comment?
As you're scrolling, yes, we can see as you're scrolling.
I don't understand what's wrong with my computer this morning. Please forgive me. All right,
Wait,
stop
that-
this. Okay, I'll put this over here. Okay, open this up again. Move this here. All right, and then screen share again. This is what I want to share. All right, you should be able to see more. Otherwise I won't be able to show you anything if you can't see it now.
That's good.
we
That's
can
good.
see it. We can see
All
it.
right, good.
All right, so before we move to old business, do we have any public comments?
I'll check right now for you. None that are in.
Okay, so the first item under old business is approval of the minutes from the March 24 meeting, which all of you should have gotten a copy of that.
Make a motion for approval.
second.
Okay,
Okay,
who made the motion?
Rob Dames.
Okay,
and second by
Chris.
Chris. Okay. All in favor?
aye.
Any opposed? Okay. Next item on the agenda is under old businesses, the consultation with nurse practitioners. We had a discussion about this. There was some understanding, or at least a rumor about that nurse practitioners might seek to get out of the requirement for a collaborative agreement with a physician during this past legislative session. And as far as I know, that bill was never introduced. It certainly didn't pass. Do you know anything about it, Van? Did they ever introduce one?
No, sir, they did not that I'm aware of.
Yeah, I didn't think they did. There was some discussion about we just ought to hold off and see what became of that. You know, I truly think it's time for us to go forward with a revision of our Practice Act. And that might be one of the things that we want to look at under those materials that were submitted on the cloud. They're given random numbers, but number one is some language that could possibly be used to sort of satisfy the requirement if nothing changes. But I think we have to be careful about putting that in the law if there is a revision, because if the nurse practitioners come back and do away with the collaborative agreement, it sort of forces us to go back and change the law again, I think. So anyways, I think my opinion is it's just something we need to think about right now and see.
Do you need it now?
There's certainly a clamor for the ability of medical psychologists to consult with nurse practitioners. It frequently comes up. It just came up again in the case of some people that work with a state agency, and most of the patients that are treated by that agency have NPs as their primary care provider, and they can't, their hands are kind of tied. So yeah, it frequently comes up.
Well, this language that appears hopefully in the center of your screen right now, I think would be something we could do in the rules and affect that ability to work, provided that they still know who is the collaborative practice physician in the situation.
So that could be done by rule and wouldn't require a change to the law.
I'm going to trust my legal eagle, but see what she says. But I think this would be the cleanest and quickest way to do it for you. But she, you know, because we can, there's no doubt that the current rule and all of the laws say physician only. Okay. Since physician acceptors, and since you're saying that the NP can do it as long as you all know who the collaborative practice agreement is with the physician and have the ability to contact them, I think we can probably do it. What do you think, Ms. Wilton?
Yeah, I mean, the rule is very specific that it says you can prescribe only in consultation and collaboration with the primary or attending physician and the concurrence of that physician. But in terms of being referred a patient, you know, presumably that MP has a supervising physician as far as we currently understand the law for collaborative practice and the advanced practice of nurses. So it would just have to be a pipeline ultimately leading to a physician.
So this would require a rule change that would obviously take effect much, much sooner than anything we could hope for in the next
We hope.
session.
We hope.
While
We
we're
hope.
talking about this topic, should we include physician's assistants or just nurse practitioners?
Are physicians assistants serving as primary care providers now?
Only under the supervision of a physician. Some do.
Are there psychiatric or do they operate in that field?
I haven't seen any.
I haven't either.
I'm not really, I don't hear any patients or have not heard from any medical psychologists that are raising that issue of PAs.
Now, if you want to hedge your bets, you could write it in such a way that states an MP may accept a referral from a qualified allied health practitioner, you know, something you could hedge your bets and write it in such a way that anyone who is qualified to make a referral like that by virtue of their ability, their existing ability by education, training, qualification, credentialing, to treat the condition for which they're being referred to you, you could do it that way. But if you just, if that's a foggy ground or a hazy area and you just want to say MPs because that's the only thing you're facing at the moment, it is a rule change, and we have a slight bit more flexibility to change the rules as circumstances require if that became an issue going forward.
Well, I would not be opposed to hedging our bets. Does anybody-
I feel like what Van has said. Van has said, look, what do you need right now? Do
Right
we,
now, we need consultation with NPs.
yeah, if that's all we need is with NPs and MPs, then I would rather keep it at least within the boundaries of what you need right now, as opposed to expanding it to other folks that we haven't even seen yet.
But this is a referral from an attending physician, not within mental health per se.
Yeah,
So
not
this would be PAs referring maybe from primary care PA to MPs, not so much psychiatry PA.
Right, most of them probably would come from primary care.
And that's really the goal of this. If you recall, one of the reasons, at least I was told when I came in, you guys educated me, was that you wanted that person who was really in charge of all of the other medications to work with you all to prevent any adverse drug-drug interactions. So the primary care provider should be knowing what you're doing, so that, and they should be able to tell you there's no problem with any drug-drug interactions that medicine you're giving, and vice versa.
Does anyone else have thoughts about that? Darla or Glenn?
Well, if we can do it simply by rule at the present time, then I think that's the way to go. You know, PAs, we get referrals from PAs, but generally when it comes from a PA, I send a note to the physician who is in charge of the PA, you know. The nurse practitioners seem to be practicing a little bit more independently, even though they may have a collaborative agreement. But PAs generally are a little bit more tightly supervised, and my note generally goes to the physician rather than the PA.
So I guess the question is, do we want to restrict it to nurse practitioners at this point? Or do we want to include other providers that work either collaboratively with a physician or under a physician supervision?
Well, if we can do both by rule, then that would be great.
All right, well then let Patricia and I revisit this language, present it to you at the next meeting. And then if that's the language you're happy with, after we hedge our bets, as Patricia said, and specify collaboration or supervision and the credentials provided therein by the supervising or collaborating physician, I think you'll be covered in any way. But the most important thing is, who's the physician that you're going to talk to when there's a problem? And that's what you're going to get.
Correct.
Perfect.
Okay, sounds
And as
good.
y'all may know, I mean, Dr. Collada can expand upon it, but as you may know, there was an intermediate step as opposed to the attempt by either the PAs or the MPs to do away with collaborative practice agreements. In the late hours of the session, the last few remaining days, Senator Luno sponsored a resolution that requires the Board of Nursing, the Board of Medical Examiners, the Board of Dentistry, all of whom have these types of arrangements, to work together on a review of collaborative practice agreements. And so keeping it as direct as necessary to accomplish your purpose, but without getting too specific is probably going to be better, because it sounds like there will be changes on the horizon in the concept and structure and function of collaborative practice agreements in general.
Okay, good. And you'll keep us posted on that, I presume.
Yes, sir, we will.
All right, great. Okay, the next item under old business, actually, the next two items are the same item. And it has to do with the discrepancy between our law and our rules. And that is that the law requires applicants for both the MP and the MPAP to have a current license in good standing with LSBEP, whereas the rule for MPAPs does not require the license with LSBEP. And as we discussed, this was simply an oversight because we have always told our members, our fellow MPs, that they did not have to maintain the license with LSBEP. And we have in fact approved any number of people for advanced practice certificates who were not licensed by LSBEP. The checklist for advanced practice applicants does not include that requirement. And I think licensing probably went off the rule when they put that checklist together. So everyone was able to pass the checklist criteria for advanced practice. And then if they met the other requirements, we gave them their recommendation. It just came to light during our last meeting that there was this discrepancy. And so we were not able to act on any applicants. They were all advanced practice applicants at our last meeting. And believe me, I've lost a few sleepless nights over that. This dilemma, one of our main functions, one of the really services that we provide to our fellow medical psychologists is review of their application for licensure and application for advanced practice. And now we're at a standstill. There was some discussion when this came to light about a possible emergency rule. And I think I remember you saying, Ms. Wilton, that the board didn't like emergency rules. And it's really not our rule that's the problem. We like the rule. We don't like that section of the law. So the question is, how do we resolve this? Is this going to require a change in the law before we can begin to review applications again?
So the rule, the short answer is it is going to require a change in the law, and it's going to require a change in the law, which is already badly written because it still only refers to the pre-2010 licensees and not the post-2010 licensees. So
right, they have the wrong paragraph number.
Yes, exactly, exactly. So it does show that's something that can be used in testimony to support the rule, that it looks like that was always the intent, that once this was up and running, maybe for the first, for the way back folks in 2010, they wanted the dual licensing or something. I don't know. I wasn't around, of course, but yeah, it's going to require a law change. And the only pushback I imagine you'll get is from the psychology board. And, I don't know if y'all are on what kind of negotiations you would want to have in advance with them about that.
Yeah, I'm not sure where they'll stand at that point. It probably depends who their executive director is. But, if this requires a change in the law, then we're not going to be able to review any applications probably at the earliest till this time next year or a little later.
Would that be unless they're duly licensed?
Unless they're duly licensed.
Right. You can't, you can't grant them, in other words. Yeah.
Not only are they, does this say they have to be duly licensed for MPs because of that mistake in the section A versus B. They also are required to hold a certificate of prescriptive authority from LSBEP, which doesn't even exist anymore. So, there are problems. There are
Well,
problems.
I fully support your desire to change the law. I don't know Pat does too. What we would really like so that it minimizes the unintended consequences, if you would allow us to work closely with your legislative lobbyist to make sure we craft this in such a way that we don't have a lot of unintended consequences like we're seeing now.
Well, of course, we would want you to do that. Before Jim Quillen died, he and I had often said, this is time for a revision to the Practice Act. And we had identified a number of things in there that were problematic. And in fact, Jim even started to keep a list of them because we were afraid we would forget when we identified something. So it really is time. And I think the question that LAMP has to answer is, do we just do a sort of housekeeping approach and just change the things that are problematic or vague and present it as a housekeeping bill where it would probably garner less resistance? Or do we really need to change some other things that need changing that might garner some resistance? LAMP has to make that decision. But my opinion is that we need to go through, LAMP needs a committee to go through the Practice Act line by line by line and identify things that may need to change and then come to some conclusion and get that done well before the legislative session so that we can get the lobbyist on board, get you all to look at it too, to see if you see any problems from your end. But that's sort of where I'm coming from. I'm just speaking for myself here. But again, that prevents us from reviewing any applications for licensure or advanced practice certification until this new law passes and is signed by the governor.
Or
Yeah.
if somebody,
Goes into effect.
And there's the question of getting that information or making that clear to everyone, whether that comes from whomever that comes, because we don't want people paying money for a license and then, application and then us saying, oh, sorry, you don't even qualify under the law. So we need to not be charging money for an illusory thing.
Yeah, that's a good point.
I mean, if your recommendation to the board is don't issue any of these licenses, that's one thing. If your recommendation is saying anybody we have not granted but is in the mill joins Louisiana Board of Psychology, then we can work those through and then they can unjoin as soon as they get it. I mean, again, it's a kind of thing that we want to make it work for you all, and your recommendation is what the board's probably going to take.
Right.
Can I ask a clarifying question? So since we're saying the rules look different than the law, and that's on us, if someone has started this process under those old rules, can we ask the medical board to grant their advanced practice because they were under the impression that that was the rule, and only have those moving forward from when we realize this forward who couldn't apply for right now?
Pat, you want to answer that for her?
So the most cautious, risk averse, prudent thing to do would be say that the committee should not grant any license that's contrary to law. And as you now know, if you acted on pending applications at the moment of granting anytime from now on, that would be essentially acting contrary to law. So unfortunately, the cautious and prudent thing to do would be to simply say to those people, the current advisory committee has become aware of a conflict between a conflict between the rules and the law that makes you currently ineligible for this.
Dr. Thomas, may I call you back? I'm in a medical psychology advisory committee meeting. Would that
And,
be okay?
just
Thank you
we'll
very
just have
much.
to fall on the sword and explain that they don't meet the legal criteria to receive it. You know, we don't really have the option to waive the law, unfortunately. If the roles were reversed, we could waive the rule all day long till we got it straight, but sadly, we don't have that option.
Well, let me ask a couple of questions here. Number one, I'm not necessarily as comfortable as I would like to be discussing political strategies in open forum. So that's one thing. Second thing, does not the board grant MP APs? Not the committee. The committee just recommends to the board. So that, and if I'm not mistaken, later down in the statute, it gives broad authority to the board to decide rules and how this process should work. So that the board could, in fact, I think, grant the licensure without the MP's approval.
But would they grant it if it ran contrary to the law?
Well, that's the part I don't know if the law is there. I have, Warren, would you send me the discrepancy there? If it's a discrepancy between law and rule, then the law prevails, right?
Right.
If it's a discrepancy between sections in the law, then that's a conflict that needs to be resolved, but
No,
not
it's-
between the law and the rule.
It's the language of the law.
Okay. So Warren, would you send a copy of that to me? So I am not aware of that.
Okay, I'll send it to you,
Okay.
Dan, no problem.
If you want me to put it up on the screen, I could probably do it for you.
Yeah,
Okay,
Well,
I'll-
It's actually the qualifications for certificate of advanced practice was already up, but that's okay. Go
Yeah.
ahead.
yeah,
I'm gonna
yeah,
go ahead.
I can pull it up myself
I'm
later.
gonna pull up the law. I'm gonna pull up the law right now for you.
I'm just interested in the section that's in conflict,
Okay,
because we've also had an attorney general opinion on this in the past, and that was not brought up by the attorney general.
okay, so basically, you have to reference 136055.
Uh-huh.
And number one says hold a current and unrestricted license in good standing to practice psychology issued by the Louisiana State Board of Examiners of Psychologists, okay?
This is for MPs, right?
Right,
Right.
but this is for MPs. Now, when you go to Certificate of Advanced Practice,
Uh-huh.
it says medical psychologists who satisfy the requirements specified in 37-1360-55A,
Uh-huh.
which is that membership,
Right,
possess all of the following qualifications, shall be issued a certificate of advanced practice.
right.
So that's what the law says, okay? So
Well,
Really?
again, we have to-
Really,
Yeah.
that should read section B and not section A. That's another mistake, but it doesn't matter. I mean, we have what we have.
right, and so, again, that's the kind of stuff we can
Well,
fix, but
yeah,
I can't undo.
but you see, to me, that's not necessarily a discrepancy, because the applicant for MPAP or for the advanced practice does have that when they qualified for the MP.
Admittedly,
it
but
says current.
Yeah,
They have to satisfy the requirements. And plus they have to have,
3 years experience, treatment of minimum 120 patients.
Yeah, that's additional requirement.
Right, but it
Right.
has to be, as I'm trying to highlight right here for you,
Mhm.
they have to have 1360-55, which is
Well,
what I
they-
referenced back here.
They
Okay,
did when they were granted the MP.
but it doesn't say, and this is where it gets difficult, and if you got an
Mm.
AG's opinion
Yeah,
that says differently, and we can track it down, I'll
Yeah.
get it for you.
I have it.
Okay, send me a copy of it, because Pat
Sure.
and I need to look at it.
Yeah.
Because right now it says medical psychologists who satisfy the requirement specified in 1360-55A and who possess all of the following additional
Additional,
qualifications.
right. Well, the additional, we know that they're gonna meet that when they apply, okay, or they're supposed to meet that when they apply. But the medical psychologist who satisfies the requirements of A, they did that when they applied for the MP.
but they have to it
They have to
appears to
I
us,
doesn't say they maintain it.
well, but
Doesn't say
they have,
to maintain that.
okay, so you get a certificate of advanced practice when you do these things. And I think that's where our problem is. And I think we're happy to look at the AG's opinion about this.
That's an interpretation.
Well,
I don't see
13,
conflict.
so you're saying you're saying that it comes into play at subpart 58 about renewal of license, where it
Exactly.
says license or certificate issued under this part shall be subject to annual renewal, and the issuance of the license or certificate is to someone who meets the qualifications provided for in the part.
Right.
So that's where the rub comes. The renewal comes, I mean, if you're saying that the first time somebody comes, they have that, and then they drop it, once they get the certificate, they drop the board of
Right.
psychology, your conflict then is going to come in 1360-58, where it says that the certificate is issued to a person who meets the qualifications provided for in the part.
Right. And the part we're talking about is the one for
Oh.
advanced practice, right?
I think the whole 1360 is the part. Maybe I'm
Right.
wrong, Pat.
No, I think you're right.
Yeah. I mean, it's unfortunate. It's unfortunate because I have no doubt what the clear intent must have been.
Right.
It didn't get written that way. And I think,
This is the point I just argued with LSBEP. So I
Yeah.
do have the AG's opinion. I have a copy of the original opinion, and
Send it to us, please.
Sure, absolutely.
Could you send me a copy, Glenn? Because
Yes.
I sort of thought that was about a little bit different issue, but anyway, I'd love to.
Well, it is about a different issue. It was about supervision issue, but the part about whether or not the LSBEP license had to be maintained is what was addressed in the Attorney General's opinion.
And
Okay.
I don't know that it, and again, is it, and Pat's going to be, I think, talking about the renewal, and I'm talking about the initial granting. So I think we have to meld those together and make sure what the Attorney General was saying about, okay?
Right.
So is the Attorney General saying you don't have to, once you get your MAP, you don't need to continue? Or does he say you don't even need to continue to get the MAP? And I haven't seen,
Upon renewal, yeah,
but there's a granting and a renewal.
right.
So do they need it to get granted the MAP? Is that what the Attorney General says? And they
No.
don't have to have it to renewal? That's why I don't know. I haven't seen the
Right.
opinion.
Right. From the opinion, I'm going off the top of my head now. It's been a while since I looked at it, but it was my impression that the Attorney General said, once you are granted the MP, not necessarily the AP, once you are granted the MP, upon renewal, you do not have to renew your LSBEP.
Well, that's what we have to look at. So if we're happy to send it to us, and Pat and I'll look at it.
Sure, not a problem.
Thanks.
Can we have some kind of discussion about that before our next meeting to kind of move this along?
You're going to have another public meeting to do it.
but
And
you
I'm
can
happy
do
to
it
set
in
one up.
executive session for attorney advice.
Right.
So if you want to call a meeting in the next couple of weeks, and you have one item on the agenda, which is executive session, receive attorney advice on this issue, you can do that.
Okay, well, let's look at the Attorney General's opinion and see if we have some legs to stand on. One other question though, because the question comes up, could we proceed with people who maintained an LSBP license and are applying for advanced practice? Or can we also look at people who are providing or who are applying for their initial MP license and of course are currently licensed by LSBP? Can we review those applications? And again, if we go back to the, not the advanced practice, but just the, that 1360, whatever it is. Okay. See, it says under A, and that's the one that's referenced, and it shouldn't be referenced, it should be B, but they also have to hold a current and unrestricted certificate of prescriptive authority issued by LSBP. And those things aren't issued anymore. I mean, they're not part of the practice of LSBP's governance because they're no longer over medical psychology. So if we look at it very strictly, we can't even review people who have maintained a license with LSBP. Am I wrong or right about that, Patricia?
Ordinarily, when something like that drops from existence, it's very similar to when boards and commissions are established and they're required to have nominations from a particular organization or group, and that organization or group becomes obsolete or fades from existence. You don't necessarily have to satisfy an impossibility. So
Okay.
if that is impossible or it does not or no longer exists, it's a gap in the law that definitely needs to be fixed. But I don't think anybody would be able to successfully argue that it was unlawful to grant a certificate to someone who didn't have that, since it doesn't exist anymore.
So if that's the case, then probably we could proceed with any applications that still hold licensure with LSBEP, the way I'm reading.
If Pat, you don't agree with that, I'd like to ask another question.
No, I do agree that anyone who satisfies what appear to be the legal requirements of 55, and then the additional requirements that still exist, you know, it would be as if the law still said you can't get a certificate of advanced practice unless your blacksmith uses X% of iron in his you know, wheel spokes or something. I mean, if something is an impossibility, I don't think we have to require, we wouldn't be against the law for not requiring it. But I think the other one is more, it can be accomplished. The only question is whether or not it has to be. And we'll have to look at that AG opinion to see if we can give you our legal opinion that it doesn't have to be.
Okay.
So the short answer is, if you have somebody who is currently dually licensed, that person's, if that person
Sails through.
yeah.
Yeah, good. I don't think there are too many of those, but obviously the initial MPs will be okay, I think, but the advanced practice is going to be less likely. Okay, any more on that topic? So we'll look for the opinion from Glenn and we'll kind of go from there. Okay, so on to new business. The first item under new business is under billing code.
Excuse me, apparently there is an individual who may want to make a public comment. Marcus Van Sickle, do you all know who that may be?
Yes.
Okay, well, are you prepared at this moment, since you're leaving this topic, to let Mr. Van Sickle be admitted and make a public comment?
Sure.
Yes.
Okay.
I'm admitting him right now.
Thank you, Pat.
Mr. Van Sickle, can you hear me?
I can, yes.
Hi, sir. The committee is here if you would like to make a public comment directly to them. The chair, Dr. Lowe, is here with the committee to speak to you.
I would, and that's just kind of listening to this discussion. I wanted to talk about sort of the piece that applied to me directly for the military. But I think listening to this discussion, what I'm not hearing is that the license needs to be active. So for example, like I still have an inactive license with LSBEP, and have held one since 2019. It went inactive a few months ago. And I guess I'm just wondering if that would not also like satisfy this requirement. It's just in a temporary kind of inactive status while I'm waiting to move to Louisiana. Because I just didn't see any language that says it has to be active, just that the license needs to be there. So I'm wondering, A, if that would suffice. And then I guess my other question is really just kind of holding out until if there's a discussion about, you know, specific to who's providing supervision for medical psychologists who are on active duty, and that I guess hasn't come up yet. So that was a component I wanted to address when it did come up.
Okay, so I guess the question would be then, and I don't know the answer to this, is an inactive license considered a current and unrestricted license in good standing?
Yeah, I think that's the question. So how do we get an answer to that, Patricia?
That's the right to BP.
Yeah, we'll ask them, unless Mr. Van Sickle or Dr. Van Sickle already knows.
I mean, I don't have that answer. If somebody had it and the answer was that it didn't count, I was simply going to log in right now and reactivate my license. So that way I could be considered during this board meeting instead of waiting an additional month. And to be honest, if we don't have an answer, I'm going to just go ahead and log in and do that. And we'll ask that the board please consider my application. If there isn't an answer suggesting that it is not a valid license.
Yeah, I don't believe we're going to be able to resolve that question today. And but I certainly, if there is an answer we can arrive at within the next shorter brief period of time after this meeting, then is certainly you could reach out to the board and or the committee and or any of the members asking, following up on the issue of the thought that we might have another meeting sooner in time than our normal interval. But they won't be able to. I don't know that they'll be able to make decisions like that in the course of today.
If we get an opinion about that, Patricia, are we able to share that with Dr. Van Sickle outside of a public meeting?
Yes, there's no problem with that. The issue will be if we can, obviously the next board meeting is the next full LSBME meeting is this Monday. So irrespective of what happens, with our communication with the BPE, that certificate is not going to be issued until the July board meeting anyway, but there could be a resolution vis-a-vis this committee's recommendation at an earlier time than would normally be, our intervals for meeting.
Gotcha. Okay. Anything else, Dr. Van Sickle?
No, thank you.
Thanks.
Dr. Van Sickle, did you want the board to address the issue of the military lack of supervision by a physician, or did you want to leave that open right now?
So I addressed that with several members of the board at the most recent LAMP conference. I'd be happy to speak on it now if there were questions or additional questions that came up, or if it was going to be discussed today. I also don't want to take up your whole afternoon. So I'm happy to say something on it if it would be helpful. Otherwise, I can hold my peace. But I didn't know if the board was going to address it today.
It's not on the agenda for today.
I would say I would like to have him address his concerns, because when we do review applications, this issue is going to come up.
Um,
So I would go ahead, sir, and go ahead and make your comments, at least put it out there so that all of us that haven't been aware of your concerns can get ready to discuss it more fulsomely at the next meeting.
Absolutely. So I guess what has come up, and previously it wasn't an issue, the board just made exceptions for medical psychologists on active service, that our supervised practice was not being done by necessarily a physician licensed in Louisiana. Our supervised practice and collaborative practice is being done with a licensed physician. But for example, my supervised practice was done with a family medicine physician licensed in Oklahoma and another family medicine physician licensed in Virginia. They both supervised 100% of my cases. We collaborated on the cases and followed all of the policies consistent with the Louisiana law. But just simply due to being active military and not being in the state of Louisiana, finding a physician from Louisiana is not always the easiest thing. Now the license, the question about, do we even need this license while we're on active duty came up, and the answer was unequivocally yes, right? So while no, Louisiana doesn't regulate federal practice follows my licensure and the limits of my licensure when they're credentialing and privileging me to provide care within a federal setting. So every limit that is placed on my license from Louisiana as a medical psychologist license is then placed on my privileging and credentialing within a military facility. Hence, applying for advanced practice, that then changes my privileging and credentialing within a military facility. Now, I'm not using a Louisiana license to see people in Virginia or to see people in Maryland. I'm only operating under my Louisiana license on an active duty military population or base or military treatment facility with supervision of physicians who are that patient's family medicine physician. So the question, I think earlier there, I think there was some confusion that I was having physicians from other states supervise me treating patients in Louisiana, and that wasn't the case. Rather, it's that patient's family medicine physician who was supervising it during my supervised time. The other question was, do we need to be licensed? And the answer to that was also unequivocally yes, right? So there are physicians in the military who are licensed by the LSBME who are practicing all across the globe under their Louisiana license, but they're doing it on military installations. So our process is a direct parallel to that. If there's a Louisiana physician in the Army and he's working in Germany, he's working under his Louisiana license, but he's working on a federal property in a military installation. His Louisiana license is governing his practice, but the federal authority is who's authorizing the credentialing and privileging. So all I was asking for in the previous conversations was to please continue the prior exceptions for active service members who want to apply for the MPAP, who have met all of the criteria. However, the physicians who supervise them may not be from Louisiana or be licensed in Louisiana, but are still obligated to follow all of the guidelines in the Medical Practice Act.
So just so I'm clear, your practice that you're speaking of doesn't fall under the exemption for a person who works solely for the government, correct? You're talking about your practice outside of anything that you might do.
No, I'm talking about my practice for the government.
Okay, well, doesn't it say nothing in this part restricts the practice services of any individual employed as a medical psychologist by the United States government in the event the individual practices solely under the direction or control of a U.S. government agency by which he is employed?
So that was my understanding. However, when my MPAP application came in, I was receiving some sort of direct pushback on my application. In fact, I received a discrepancy on my application because my supervised practice was under physicians who were not licensed in Louisiana. Both of those physicians who supervised me were active duty service members, and they were supervising me working with active duty patients in Pearl Harbor, Hawaii. But that was So that was where the question came up, is when I was applying for MPAP and who my supervisors were, or more specifically, where he and she were licensed.
Okay, so it's a gap between additional requirements for MPAC versus just a plain MP.
That's my understanding.
Okay, I understand.
And I had started the MPAP process almost 4 years ago, after reaching out to Dr. Quillen to say, you know, I can meet all of these. I can do the 100 CMEs. I can see all of the types of patients under supervision. However, I'm not going to find a Louisiana physician at my military base. And at that point in time, and granted that was years ago, you know, he had emailed me saying that this has been that precedent has been set that the board waves these through. But you know, fast forward a few years, once I finally met all the requirements, and unfortunately Dr. Quillen has passed, that same sort of pass through is not extended.
Okay, well, I haven't been involved in those discussions, and I'm not ready to give my thoughts on it today. But I think just looking at the requirements for certificate of the advanced practice and then superimposing that, or superimposing the exemption for a person solely working under the direction of the government. I'm not sure that the former practice might not have been correct, but I don't question anybody's decision in the interim. I've not addressed this issue myself.
I'll just say that historically, we have approved that type of military supervision.
Correct.
So anything else, Dr. Van Sickle?
No, that was it.
Okay, thank you. Appreciate it.
Thank you. Bye.
All right, so let's move on to new business, billing codes. LSBME received an inquiry from LDH about, and that's, you should have as part of your handout or on the cloud there, that letter that requested information about, and it's actually number 3 on the cloud information, whether medical psychologists can bill E&M codes or whether they can only bill psychotherapy codes with the 90863 add-on. And Glenn, you work for the state, you know this.
Right.
My answer is that psychologists can bill, medical psychologists can bill EME codes, but not all EME codes.
Medical psychologists should be able to bill for E&M codes. In fact, there is an opinion by the board that was issued before Dr. Collada became the executive director. It was issued by the board indicating that medical psychologists are qualified to do all the assessments necessary to bill E&M codes. However,
can they bill the E&M code for medication management? See, that's
yes.
the one I'm told they could not do.
Yes, they can.
Okay.
Having said that, it does not necessarily mean that the insurance companies have to pay for it. Okay. Right. Just because you can bill for something doesn't mean you're going to get reimbursed for it, basically.
True.
So that we have the authority and the ability to bill for E&M codes. But as you well know, and as most well know, Medicare, the 500-pound gorilla in the room, has decided that they will not honor medical psychologists billing for such codes. So that's the way it stands. And since most LDH clients are either Medicare or Medicaid, Medicaid does allow for E&M codes, Medicare does not. And that's a large percentage of LDH clientele. So that's why they are so interested in medical psychologists billing for E&M codes.
So say that again, Glenn. Medicare does not allow for E&M codes?
Medicare does not allow medical psychologists to bill for E&M codes. Now, let me put it this way. You can bill for them, but they will not reimburse medical psychologists for E&M codes. Medicaid, because it is operated by the state, does reimburse for E&M codes.
But so you'll know, Medicare would be considered their primary provider, and then Medicaid would only pay what is the 20% that Medicare does not pay. And so
Correct.
you would in essence be doing the work for 20% of the full charge.
Exactly. And that's what LDH would get reimbursed. Now, obviously, they're looking to be reimbursed for more.
So the answer to this person's inquiry is yes, medical psychologists can bill for E&M codes.
Correct.
And I'm told that for 90863 for the CPT code, that most commercial insurance does not pay for that. I don't know if that's true or not.
That part I don't know, since I don't do any commercial insurance.
Do you happen to know, Chris?
So is that the psychotherapy add-on to the med management E&M code?
Right.
Yes,
Yes, they will pay for that.
they pay for it here where I work too.
Okay.
And that's because of something we're going to talk about later, which is mat therapy. So yes.
Okay. All right. So will someone on the board respond to her?
I will take care of it.
Great, you always do. Thank you.
Okay.
All right, next item on the agenda is CE Broker. CE Broker had a problem with the ethics requirement and their software. They couldn't accept both CE and CME for the ethics requirement. So what they did was made a decision that the CME ethics was acceptable to their software, but CE ethics was not. Apparently it's gone fairly smoothly this year. Last year, I had questions for 4 or 5 weeks from people that couldn't get the system to operate so that they could actually complete their renewal. This year, I've only had 3 or 4 inquiries, and when I forwarded those on to CE Broker, they've all been taken care of. The only problem and really this is probably a moot point now because the renewal deadline is June 30th, just a few days away, a week away. So the problem I have with them excluding ethics CE is that really goes against the law. We have always, and I think the law and the rule backs up that CE ethics is acceptable, and we've always accepted it until CE Broker. And this is apparently a new issue with CE Broker because I didn't get this feedback from them last year. I'd like to be able to allow people to use either CE or CME for ethics because that's what the law says they can do. But right now with CE Broker, we're not able to do that.
Okay. Can I make a comment, Warren?
Please, please.
Okay. We are moving away from quote ethics courses of any type or jurisprudence courses to law and rules courses. And we have a specific law and rules courses for MPs. And so that would cover everything you wanted it to be because it is the practice of your specialty differentiating itself from the practice of plain psychology. And it would cover everything you all need to know because you're going to be held responsible to the law and rules for MPs, not the law and rules for psychologists. And the goal of this ethics course is to teach you all what you have to do to be your specialty. But we don't even call it ethics anymore. We call it law and rules, and it's free for you all to take.
Right, but Van, that's a one-time thing.
No, you can take it
No,
anytime.
you can take it every year.
You take it every year?
Every year.
But
Wow.
it's only 1 hour, correct?
2 hours.
2 hours. But you have to take it the first time before your first renewal, and you can take it every year for free.
Okay, well, that's certainly an option, but you know how our members are, okay? Somebody's gonna take an ethics course in Timbuktu and gonna want to count it in some kind of way rather than the CE broker or the LSBME ethics course. We have to have that latitude. However, I do understand CE broker's position that it is difficult to automate that to get it to be CME or CE. It seems to me that CE broker needs to have a third category, CME, CE, and ethics.
Okay, well, let's talk
That's
about
basically
continuing
what they
education.
do.
Let's
Yeah.
talk about continuing education dash ethics.
Right.
Okay, that could be about the ethics, because continuing education can be about anything, not medical. And it can be about the ethics of banking.
No,
Or no,
No.
where does it say it has to be about the ethics of psychology or the ethics of medical psychology?
we've had this discussion before. Could someone take a CE course in Microsoft and get credit for that? No.
No, not Microsoft, but
Yeah.
the ethics of Microsoft.
Yeah,
It could be left a Microsoft ethics course.
if it is APA approved, or if it is LSBME approved, or approved by nursing, or approved by one of the medical associations that approve CE, then yes, it would count.
Well, the key here is that the board would happily approve anybody taking the law and rules course, and it has already done
Right.
so.
Right. And I'm not arguing against that. What I'm saying is that we're going to have members who do not want to take that and take it elsewhere, get it elsewhere. Now, we've already heard complaints about having them necessarily take hours from LAMP. If you now say you're going to have to necessarily take hours from LSBME as well, we're going to hear some pushback on that.
Well, again, LAMP requires a membership to get the hours for free. All you have to have is the license to get the hours for free from us.
Right.
And it would fulfill the ethics requirement if any member, even a non-LAMP member who's licensed, takes
Right.
our course. And so I think we offer a broader base of
I'm not
activity.
arguing against the course.
Okay.
I'm not arguing against the course at all. Not at
Well,
all.
I think
in
I
favor
can
of-
bring it to the board.
Yeah.
I can bring it to the board and well, again, but the board has said they want people to take the law and rules applicable to their specialty or
And I'm
their
in
area
favor
of
of that.
license.
I'm in favor of that. But this also has to, like I said, we have dual sort of relationship here. We have medical side, we have psychology side. There needs to be some psychology ethics in there as well.
Well, again, the practice of medical psychology is the practice of psychology, isn't it?
Both, yes.
Okay. So my concern would be if we're going to try and do away with the requirement to be licensed as a psychologist as we change these rules and laws, why are we going to require a psychology ethics course? And why not it just be the ethics and or the law and rules for medical psychologists?
And,
who
and
no
I'm
longer
okay
wa-
with that.
Okay.
I'm okay with that. The only problem I have is the exclusivity of it.
Well,
That's-
you can take a law and rules course on medical psychology from somebody else, but I don't think it'll be tailored to Louisiana.
I
Okay.
agree. I
But
agree.
again, you're going to have a one time with Louisiana,
Mhm.
period. And then you can
Right.
get 2 hours free every year by taking that same course again. Because
Exactly.
remember that right now we have a law and rules course that says a certain thing. As we go back to the legislature and rewrite that legislation next year, the law and rules course will change.
Change.
And so you would be getting that 2 hour free CME, and it would always be the
Current.
reflective of the current law and rules.
Exactly. I'm with you. I'm with you on
Okay.
this.
But again, if y'all want to do something else, you tell me what you want the board to do, and we'll
Mhm.
ask them to do it for you.
Right. No, I'm with you on this.
I just want to clarify. So I think I'm absolutely okay with the board saying that you must if that's what the board wants to do, you must take this course every year and this counts as your ethics. It's absolutely up to the board if they want to do that. But I think the point is, if that's not the rule, and if CE broker is allowing you to enter CE, why is it only requiring CME and not CE? Why couldn't you do either? That's the question. But if the rule becomes you have to take this one course, then it's moot. But as long as CE broker is asking you to pick one or the other, it becomes an issue because some people get CME for their CE and some people get CE for their CE.
Right. It doesn't sound like y'all are asking for CE broker to recognize random, basket weaving and badminton courses. You're just asking them to recognize a course that would otherwise qualify. It's just categorized as it has different initials in front of it instead of, it's just like a formatting issue or something, not a content issue.
Exactly.
And we can ask CE broker to do that for you. But again, I think what you want to do is we're going to ask the board to approve that, because the board wants you all, it wants all of our licensees to be well-versed on the law and rules applicable to their area of practice.
All right.
So that,
I think, Dr. Van, if I'm not mistaken, I think what they're talking about is like sometimes for us attorneys, we might choose to go to a 2-day program somewhere else that satisfies all of our requirements for Louisiana, but it's off somewhere else. And we have to come back to the Supreme Court and say, hey, look at this MCLE. Did it qualify? Did it meet all the criteria? If so, will you approve it? And then we can count that. And so I think they're talking about circumstances where it might be part of some other thing that they're attending. And just because of the way that organizer has formatted it, the CE broker's not recognizing it as a qualifying course. It doesn't sound like they're trying to not have people be qualified and educated and up to date. It just sounds.
and I'm happy to do that, but just remember that now as you get to these individual courses, the board is going to probably ask you as the advisory committee to make the recommendation to approve the course. And are you all prepared to do that on a regular basis?
Well, I'm really very much in favor of the law and rules course, and that's what I use for my ethics CME. And that's what I told people who are running into problems getting their application for renewal completed, was to go ahead and take that 2-hour course and put it in. And when they did, everything was fine. I'm no expert on software by a long shot. You could probably put what I know about software programming on the head of a pen and have plenty of room left over, but it doesn't seem like to me it would be a hard thing to have an either or for CME ethics. The software would accept either one. Marcia Mann has, and I've had this discussion with her any number of times this spring, they cannot do that. The software does not allow it. It will only allow one, and they're going to go with the CME. So I don't know the answer to it. I agree with Glenn that people are going to, if the law says that they can take a CME, an ethics course from APA or from some other recognized provider in the law, they're going to do it. And then they're going to be upset that a CE broker isn't going to accept it.
Well, again, like I said, if these, just like like Pat alluded to, that you want to get these approved and we can consider them, we'll do that like the Supreme Court does. And I'm sure the Supreme Court doesn't necessarily respond as fast as the lawyers would like. And this has to be done in advance of the time that they go to renew, or they'll be problematic with renewal. So I'm willing to say, you guys want to, I don't think the board is going to say, we're going to approve them. They're going to ask you all to approve them.
If they're from an approved provider, if they're from APA, or if they're from the state of Louisiana or whatever, there's no need to approve them. They're already from an accepted provider. Why couldn't we just put a clarification on the front page of CE broker that says enter any CE, whether CME or CE as CME, and you're done?
Tell me who's the approving agency and we could probably make that happen. Do you want just APA?
Well, it's mentioned in the law about who we accept. Sponsors shall include Louisiana Psychological Association, American Psychological Association, and other sponsors as may approved by the board.
And that's
Uh,
going to be your job to approve them.
Right.
I think if you just put APA, LAMP, LPA, and the state of Louisiana, or whatever we approve, that would probably cover everybody.
Well, I think we're getting away from the issue here. It's not approval or the issue is, what do we do to get CE Broker to accept a
I think
variety of ethics?
We can, what we're going to do is we're going to trick CE Broker and say that APA, LAMP, whoever else you say, remember that the state of Louisiana does not accredited CEs, okay, of any type. So again, but again, if we want to give those 3 or 4 nationally accrediting things, I think we can make CE Broker work for you. It's the ones that become mom and pop and not accredited by a national organization that
Right,
we're going to have problems with.
right.
Okay, but it's them being, it's them being coded as CME or CE. It's a
Correct.
coding
Right.
issue.
Correct. It's
And we
CE
can
Broker
fix that.
proven. Okay.
We can probably fix that, and I do think we can do it if we have national standards on the approval, because one of the things we have found is that it's better to have national standards than mom and pop that the advisory committee approves on a regular basis. Because
Right.
A, it doesn't get done timely, B, we have to charge people for it, and if they don't pay, we can't do it, and then everybody gets upset. So again, I think we're trying to figure out a balance here. And I'm happy to make it work. I think we can make it work with CE Broker. If you say APA, LAMP, and with the, Ms. Dr. Dahl, you said one other one?
LPA,
Louisiana.
or we can discuss that list, and I think.
Yeah, because I mean, you got ACOG with nursing, you got a number of
Well, ACOG, wait a minute. You can't get nursing. I don't think you would allow, or you really want, psychologists to take nursing continuing education units.
They offer some good continuing education in terms of assessments, in terms of, I don't know.
But
about
this is about law and rules or the ethical practice of MPs.
Right.
And you think the nursing boards can, American Nurses Association will be able to do that? Because they don't even know what our laws are.
Probably
You
not.
know, so again, I think the key is if you want LAMP, I think I can work with Marcia on a national group to make it work for you. But
Okay.
again, if you want to do mom and pops, we'll present them to you at every meeting you have.
Yeah.
Well, there's so many possibilities. You take one from the Texas Psychological Association, the Mississippi Psychological. I mean, the list is endless.
Well, what we normally say is agency that would give, for example, for our docs, we don't care who does it, provided they get an AMA, CME approval. So if you don't have anything like that, that's why we would say maybe APA. Does Texas
Right.
get all of their, Texas Association get their APA to approve theirs?
Yes.
Does LAMP get APA to approve all of theirs?
No.
No,
Okay. So
We're
then you can say
statutory.
LAMP and APA, and then and then LA Board of Psychology, and that would be the 3.
Yeah, we can look at the list of those. Not a problem.
Okay.
I mean, I really don't have a problem with telling people early in the renewal cycle, look, if you don't want to run into problems, take the rules course, the law and rules course, and use that as your ethics CME. It really is a good thing to do. I like the course. It's always good to have that renewal, but there are going to be those people that just, oh, here's an ethics course, I'm going to take it.
And we just heard from Dr. Van Sickle. I'm sure he can take it online, the ethics course, but he may have ethics course in the military that are they going to be approved providers?
There's a letter in the cloud stuff. It's I don't know what number it is, but it's somebody complaining about, this not being CE, and it's let's see, it's number
2, right there,
Mark Zimmerman.
right there. right
yeah,
there.
number 2, yeah,
Zimmerman.
Zimmerman, yeah.
Complaining about what?
So, it's going to stir up some feeling, but I think if we let people know ahead of time.
Yeah.
And keep reminding them that this
Right.
is where you get your ethics.
That's the key for our folks.
Daily reminders.
It has to be continuous.
Okay, well, let me say this to you. As soon as you all settle on what national accrediting agencies you want to work on,
Right.
I will work with Marcia to fix it, and we'll send out email blasts to all of the medical psychologists that we license.
Thanks, Van. That'll work.
But I need y'all to tell me
Yeah,
so that the board can approve it.
right. We'll give you a list.
All right.
Thanks.
Yeah, that'll work. And, well, I'm not even gonna go there. That's enough of that. Okay, next item on the new business is buprenorphine, and there's a handout or attachment on that. I think it may be number 4. We've received an inquiry from someone who works for the state, and her medical director, who happens to be a psychiatrist, is really interested. They have not nearly enough providers to treat opiate addiction, and they're very interested in having medical psychologists be able to prescribe Suboxone or buprenorphine. Our law says that we can't prescribe narcotics that are used to treat pain. Buprenorphine is not used to treat pain. It's used to treat opiate addiction. And it doesn't have a FDA indication for treating pain. It's only has an FDA indication for treating opiate dependence. So I think it's a good point to consider and take a look at. The DEA is really loosening the requirements for buprenorphine prescribers. I think it wasn't that many years ago. If you were a prescriber, you could only have 30 patients you were prescribing the medication to. And then, and correct me if I'm wrong, but then after you had done it a few years, they changed it. And if you've been prescribing it for 4 years, you could increase your patient load to 100 patients. And then it grew to 250 patients. And now they've done away with any number of restrictions on the number of patients you can see. They've also eliminated the disciplines that there's no restriction on the disciplines that can prescribe it, whereas there used to be before. So the requirements are really that you take that 8-hour course that we're all now going to be required to take to renew our DEA license. That's basically the only requirement that the DEA has for prescribing this medicine. So the question really is, we can't prescribe narcotics that are indicated for the treatment of pain. Can we prescribe this medication? Because it's not indicated. Now, what this would require is a revision to your DEA license and your CDS license to include class 3 medications. So give me your thoughts about that. I don't know if you've had a chance to look at that material from Lisa and some of the DEA material that I included on that.
My only question, Warren, because I read through it all. So if you're going to update your CDS or your DEA, if I was going to prescribe this medicine, is it listed as a narcotic under their database?
Yes, but it's not listed as a narcotic for the treatment of pain.
Okay, so then there's a way to clarify that when you apply for those things.
Yes,
No. Well, go ahead.
You used to have to get a federal X waiver to utilize this. Now, and for example, when I was in practice 5, 8, 10 years ago, if we had a patient who needed their Suboxone or buprenorphine, I couldn't even write it in the hospital. We had to get a doctor who had that ability to do so. And so it was frequently an addictionologist or a family practitioner or internal medicine that did a lot of this, and they would have to be consulted to do it. Now, because of the overwhelming number of deaths and overdoses from fentanyl in the market, because really now it's not what we are prescribing that's killing patients, it's what the black market is providing. And I think this is a way to treat, and they really want us to do medical assisted therapy so that the medication is only part of it, and it fits so clearly into what you all do. You can give the buprenorphine, but you still do the talk therapy to deal with them in the regards of their addiction and how you deal with that. I don't think the board's going to have a problem with it. I'm happy to present it to them anytime. Pat, do you feel the same way that I do in reading the law? I guess you had missed us. You're still muted, Pat.
I will say that nurse practitioners are prescribing it now, and they indicate that they're prescribing it for opioid dependence. They're not prescribing it for pain. That's
And again,
part of the way they
again-
write the prescription.
but it's also at that point, they have to have a collaborative practice physician who is knowledgeable doing it and granting them the appropriate guidance to do so. So that's a little bit different than you all. Because and I think the key here is you all are appropriate to do it. You're not treating pain, and you're going to be the people. See, because sometimes the nurse practitioners aren't there to do the therapy that it needs to come. Medically assisted therapy needs to be combined with both buprenorphine and the therapy that has to go with it. And, you know, again, Patricia, do you interpret the law the same way I do?
I
and the
do. I
rules?
do. Sorry. For some reason, my mute button is just not cooperating today. I absolutely agree with that. It's to treat the condition that you're qualified and authorized to treat and use the appropriate medication, whether not irrespective of whether it could be used by some other practitioner in another context.
Dr. Collada, what would you think would be the best way to get this opinion out? Do you think it would be an opinion from the board, or how should we handle this?
Well, why don't we do this? I would have to get, if you want, why don't you do this? Why don't you make a recommendation to the board that everybody votes on so that we keep it clean, and that you ask me in that recommendation to attempt to get it on the Monday agenda, and I will get it on the Monday agenda. And we can have that then sent out as a statement of position that Patricia and I will draft and send out. And then we're happy to do that. That's probably the fastest way to get this buprenorphine issue addressed.
I would move that we endorse Dr. Collada's motion to the board that we expedite an opinion on medical psychologists prescribing buprenorphine for the specific purpose of treating substance abuse.
I second.
Or can we say opioid dependence to make it more specific?
Well,
'Cause
I think
that's
it's
what
opioid
that's
use
what the
disorder.
indication is for.
I think it's called OUD.
Opioid use disorder.
Yeah,
Okay,
correct.
all right. Is there a second? We have a second? Bob, did you do?
Yeah, I second it.
All right, thanks.
With that correction to OUD.
Okay, sure.
Sure.
Any discussion before the vote? All right, all in favor?
Aye.
Opposed? Okay.
I'll get it done Monday for you, and we'll
Thank
start
you.
getting the stuff printed and hopefully get it out pretty quickly.
Let me ask one quick question about the change of the DEA license. When you indicate what schedules you're prescribing, for example, if we now indicate Schedule 3 narcotic, because I think they have Schedule 3 non-narcotic and Schedule 3 narcotic, unless they've changed that. We don't actually list what medicines we're prescribing. We just check that box, right?
That's
Right.
correct.
Yeah. Okay, so,
So you're gonna ask for Schedule 3, okay?
Excuse me, Darla was logged off. She's asking to be logged back in.
Jacinta, Olivia, can you fix Miss Dr. Darla? Here she comes.
Yes, Dr. Arlo's coming in now.
Basically what I was saying is you can prescribe, you will have the DEA's permission to describe any Schedule 3 you want. But if you're treating pain doing that and we get a complaint about it, you have to answer to the board for it with discipline. So I think one is you can get as long as you're using the Schedule 3 to treat opioid use disorder, you're fully within your rights and license in this state.
That's what we wanted to say. That's
Would
what we
that-
wanted to say.
That's what we want right there.
All right, we were happy to do that for you.
Thank you, sir.
Darla, are you on, Darla? No, she's not on, okay.
Yes, I'm back.
Okay, I didn't know when you went off. Did you hear the motion that was made?
I caught the tail end of it.
Okay, so Dr. Van's gonna take this to the board on Monday with.
I have a question about that. So does that then open up the option to prescribe a Schedule 3 off-label for any psychiatric condition?
Not
Okay.
that rule that it's
And
opioid
opioid use
disorder
disorder.
only,
It's going to specify OUD.
OUD only.
Only.
Good.
Okay.
And I think Van's right. I think that what will happen is if somebody, gets approved by DEA to use a Schedule 3 drug and use it outside of the rule and gets into some kind of trouble, somebody reports them or whatever, then the board will obviously adjudicate them
Yeah. And
or do something. But I think it's appropriate. The folks up in at the FQHSA who are trying to do addiction treatment, and they don't have enough prescribers up there who are MDs. Absolutely, look, we got to treat drug addiction, right? We as a board committee shouldn't step in the way of that. We should help it. So I agree. I think that this is a way of doing that, opening it up to MPs who have, Class 3, Schedule 3 approval, and then follow the rule that's here.
And excuse me, Mr. Chairman, Dr. Chris, it's my understanding, and Pat, you correct me if I'm wrong, that you can use any controlled and dangerous substance as long as you're not prescribing it for pain. So if you want to prescribe an accepted utilization, and I would be careful to say off-label could be a problem, because if you get into an issue of off-label, did you use the proper protocols for off-label? Because that can get you in trouble. But if it's a Schedule 2, Schedule 3, Schedule 4, Schedule 5, and it's approved by the FDA to be treating that condition, you're golden.
Well,
what-
yeah, I mean, I'm not saying that's wrong, but I'm saying we don't need to go into that to address
Okay.
the question that was asked of
No,
us, and we
no.
ought to keep it limited.
Thank you, Pat. Thank you.
All right. It's just going off label is going to be real dangerous.
Yeah, definitely. Okay.
Okay.
Great on that. The next item under new business is deficiencies in licensure application. Basically, this refers to complaints that we often hear about the delays in getting their applications reviewed. And it's an ongoing complaint. It's
There.
it's kind of a mute issue until we get this discrepancy between the law and the rules resolved. But I think we need to do better than we're doing in terms of getting people information about where their license stands. I had someone email me. No, actually, it was in a text just a day before yesterday, and I probably should have included it on this because it really speaks to the delay that this person has encountered and the difficulty she's had in getting feedback. Plus, I'll use the example of last August, we reviewed some applications, and I think there were 6 applications and 2 of them had deficiencies. They weren't major deficiencies. They basically just had, as I recall, had to submit an updated attestation form. I don't know what you call it, but it's that form where they check whether they've had any complaints or arrests or anything like that. And the date on that was too early because something had happened with those 2 people. It had been successfully resolved, but we just needed a current form, a dated form. Those people who were reviewed in last August have never heard about what their deficiency was or why their application has not been acted upon. So my feeling about that is we just got to do a lot better than we're doing.
Warren, if I make a comment?
Sure.
Okay, I just pulled the data and I have exactly 1 medical psychologist initial license in process. I have no others. Okay, that's the only one I have. And so I think we're keeping up with the workload. That's number 1. Number 2, everybody now has a portal and had one as recently as October. And we reply and send the information on deficiencies to the email address that they give us. And frequently what happens is somebody may have an email address at lsu.edu and then leave that institution after they put their application in and not change it in the portal. They will never get an email from us if they do that. Now, every time the ladies in licensing and the gentlemen in licensing work in a license, every time they find a deficiency, they send an email so that we get, people get emails. I had one guy not too long ago said he never got an email. We have confirmation that the email was sent and received. Okay. But where was it going? He had it sent to his former office manager's home email address because that's where she wanted it. But he never changed it in our system. So again, I can't do anything except send it to the email address that you all and people give us. And that's the one thing I can tell people time and time again that delays knowing what the deficiencies are. But I just pulled up the data and I will tell you that when give me a second, and I will tell you what the date of that initial application was. Give me a second. And that was from 5/17/23. We have had no licensing input since 5/17/23, and everything above that except the ones that we're holding in abeyance for the advanced have been done.
Okay. Well, obviously, if people are not giving you current information, they can't expect to be kept abreast. But I don't know, Chris, Darla, have you heard, or is it just me that people text or email about problems with their application? Have you heard anything,
Yeah,
Chris?
people stop me with kind of the same, just the delay. And I've subsequently instructed them to check the portal, contact Dr. Collada. That's kind of my general response.
And we appreciate that.
I guess my question would be, so the person who sent this email, I know I don't think he's on our agenda for today. So is his issue being addressed?
Okay, let me go back and pull up the email. Give me a second. I apologize.
It's the one you have on the screen right now.
Okay, I just can't, I have it hidden in mine, okay? All right, let me just pull it. All right, so let me pull up his individual one and I'll check on it for you. Okay, we don't know what his name is. Richard Gunn. Okay, COS.
Do we want to talk about people's individual
We can do that in
Personal
the executive
issues in
session.
public session?
Yeah, we could do that in executive session, if you don't mind, Dr. Dollar.
No, I'm fine. I just want to make sure that's getting addressed. That's it.
Okay, we'll do it in public, in executive session.
Okay, do we have a motion to go in executive session?
Sure.
So move.
Second. All in favor?
Can I ask one thing real quick? So
Sure,
we had added telehealth to the agenda. Was that for open or executive session?
that's for open. We'll come back to that.
Well, then why don't we finish all the open business
Okay.
and then handle the other one?
All right, let's do telehealth in it.
I withdraw my motion for executive session.
Okay. You know, we get lots of inquiries on our listserv about telehealth and what the requirements are. And medical psychology does not have rules for telehealth. And so I think most of our members have been following the rules for physicians as best they can. But the issue that seems to come up most is, where does the provider have to be located and where does the patient have to be located? And when I look at the physician's rule on that, if I can find it, early on in that rule, it says a physician using telemedicine may be at any location at the time the services are provided. A patient receiving services by telemedicine may be in any location at the time the services are received. Then later in the rule, it says, no physician shall utilize telemedicine to provide care to a patient who is physically located outside of this state unless the physician possesses lawful authority to do so by the licensing authority of the state in which the patient is located. So I think that's where the confusion comes in. Can you provide services to a patient who's located out of state? Or can you only do that if you happen to be licensed in that state? And here's the issue, really. A lot of times we're seeing patients who are temporarily relocated out of state for work or college or what have you. It's natural to want to continue to provide services for those patients if they're in a crisis. So can you do telehealth with someone who's located out of state?
Well, first of all, I think the big key is a domiciliary location as opposed to temporarily out of state. So number two, by convention, the state of domicile of the patient would be where you have to have a license. Now, let's take the issue of a crisis. It's very, one of the things we say in telemedicine is that you have to have the ability to get a backup situation if you're going to be treating people. And so if you're treating somebody in crisis who happens to be living in Missouri and you have a Missouri license, how are you going to handle that crisis? That becomes your decision, okay? Their state may not have an issue relative to crisis. But if the doctor in Missouri, licensed in Louisiana, does not be able to handle the problem of the crisis, that's going to be an issue for his license in Louisiana. So again, first of all, convention is the domiciliary place of the patient. Now, it's just like right now today, and for 50 years, if my patient happened to be on vacation in Florida and called me and said, I have a urinary tract infection or I'm pregnant and I have a yeast infection, we would treat them, and that's not a problem because they're not domiciled in Florida on vacation. They live in Louisiana. So the key here is, I think, understanding that if you're treating a patient who really is living in another state, you have to have the license in that state. Number one. Number two, if you're treating them, you need to follow the license of their rules. If the person from out of Louisiana is doing it in Louisiana, they have to follow Louisiana's rules. I'm not sure that answers your question, but if it doesn't, let me know what I haven't made clear.
No, I think that does answer the question. So the provider, though, can be out of Louisiana, even though he is licensed in Louisiana. If he's temporarily on some sort, I don't know, some sort of traveling assignment, but it's temporary, but he's out of state when his Louisiana patient says, I need a telehealth session. Can he do that?
Yes.
It's
Okay.
my understanding if that person is licensed in Louisiana and normally the doctor is normally his office is in Chicago, but happens to be in Hawaii on vacation and chooses on his vacation to treat the patient in Louisiana with his Louisiana license, he's fine.
Okay. All right. I think that answers most of the questions that tend to come up over and over again.
Yeah, I
So-
think the
Go
key
ahead,
is,
Glenn. Sorry.
I think the key is, where is the person licensed and where is the patient living? Okay, living, their actual domicile. The
Yeah.
student is a
Where-
temporary
Where are they
situation.
registered to vote if they happen to be a voter?
Yeah,
Uh,
so
That might help.
I think there's another issue here that may need to come up. And Van, I would appreciate your comment on this. But if their domicile is Louisiana and your license is Louisiana and they're in Pensacola, Florida, and they say, oh my God, I forgot to pack my medication. Can you call in a prescription for me?
yes,
Now,
Again, that works in some states because they accept my license in Louisiana. For example,
right.
we'll take Darvocet, it's been off the market, so we don't have to worry about it.
right.
Darvocet, we used to prescribe for patients over the phone in Florida without any trouble. Now, given the change of the way the world is moving, okay, the key is we have the issue of some states like New York. I can't prescribe, you can't prescribe in New York any kind of controlled and dangerous substance. In Louisiana, technically, and this is what you need to know, if you're licensed in Louisiana, have an office in Chicago, and you're doing telemedicine in Louisiana, or telehealth in Louisiana, as it's going to change to, and you want to prescribe a controlled and dangerous substance, you're supposed to have a state CDS license.
Right.
So all of the states are now changing a little bit, and you'd have to know which each individual state of where that person is. Right now, Florida and Louisiana recognize each other's transitory patients. I can't tell you what, and I can tell you New York does not, because New York would not let me prescribe 5 years ago, when I was trying to get somebody some medicine in New York. However, Texas does recognize my ability to do that. And that's a problem we have no control over because it's different states doing it differently.
And
Yeah,
Rob, what I
I
generally did with that, Rob, was I would tell the patient, I will send a prescription to the local CVS here. You find a CVS over there and see if they will transfer that prescription.
Right. I was going to suggest that that probably is something they need to consider.
Right.
Okay, any further comments or
Dr.
questions?
Colada, for the promulgation of the rules for the telehealth, is that something that this committee gets involved with on the MP side?
We will certainly show them to you, but at the present time, there is a law in the statutes that governs telehealth. So while it's great that you try and emulate the telemedicine rules, you are bound by the telehealth rules that currently exist in statute. That will all change in January of 2024 because of SB 66,
Right.
which was passed and enacted into law. So again, yes, as we will never present a set of rules to the board unless you all have seen them if it affects your area. But in terms of right now, what you're governed by is the state statutes regarding telehealth.
Thank you.
Thanks. Anything else on telehealth? Okay, motion to go into executive session.
So moved.
Second,
Okay, all in favor?
aye.
Okay, so,
You
can
just
you-
sent a little time.
Give us, we have to move into executive session room.
okay,
You should see something that says join. Click on that blue window, blue button that says join.
Alan, I'm gonna leave you outside of executive session.
Warren, there's one thing I do need to update you all on, and that is the impact of SB 201, which was a bill to address electronic meetings. And we can continue to meet electronically. The look and feel of the meeting will differ slightly because we will have to have a central area, which we will use as our building, for visitors to come in or people that want to appear, and we'll probably use the boardroom because it's all set up to do so. And we can have them, they have to have a central area under this new law. And Patricia and I are working out the rest of the details. But basically it says whoever is the moderator of the meeting, and while I would moderate, you are still the chair, and I think that'll work for everybody.
Yes.
So just to clarify, Van, somebody like Dr. Van Sickle today has to come to that meeting room and.
No, he
No,
doesn't.
no, he doesn't have to, but if people want to come
Oh,
physically,
gotcha,
they
gotcha.
can come.
You have to
It-
make
it was-
availability to the public. You have to
Yeah,
make,
it's an anchor location
Excellent.
for people who choose not to do things via internet.
Okay, good. All right, thanks. And when does that go into effect? We don't know.
Hang on, I'll have to look to tell you. If you give me a second, I'll find it for you. Give me a minute.
it's not going to affect us unless you want to go to LSBME for the meeting.
Will we have appetizers?
No. Nope,
Is there an open bar?
Dang,
nope.
Wait a minute, then what's the point of going, right?
exactly.
We're trying to make it easy for you all.
Yeah.
All right, let's see. Trying to find the effective date of the law, and I
Well-
guess,
I was just asking out of curiosity. It isn't gonna affect what we do.
right. I think probably by June, July, we have to have it in effect, is the way I understand it.
Okay. All right, any other comments, business before we adjourn?
Anything from the public?
Let me
We've
check
already-
real quick. I'll check for public comments. Nope, no public comments have come in by email.
Make a motion for adjournment.
Second.
All in favor? Thanks, everybody. We had a good meeting. Appreciate it very much.
Thank you.
Thank y'all.
All
See ya.
right, take care.
Have a good weekend. Go Tigers.
Go Tigers.
Go Tigers, yes, indeed.
Have a good weekend.
Bye-bye, everybody.